SJC-13823, Commonwealth versus Jose and Solis.
Okay, Attorney Hartley, whenever you're ready.
Good morning, and may it please the court. Brooke Hartley for the Commonwealth. As your honors know, this case concerns the exact same legal issue as Diaz and a very similar fact pattern. So I will not repeat everything ADA Campbell argued, but I would like to focus on a few specific points, of course, unless your honors have other questions. First, I think it's easy to conflate privacy interests and possessory interests, and a seizure affects only possessory interests, whereas a search affects privacy interests. So I think a central point here is that the purpose of securing a warrant in a closed container or in a cell phone, like in this case, that is believed to contain either contraband or perhaps probable cause that there's evidence on the phone, is to ensure a prompt return of that object, where there would be no return because that piece of evidence in this case is going to be held throughout trial, that possessory interest no longer exists.
Well, then, but what is the legal principle that you're relying on to say that even when you have a lawful seizure, that eliminates the obligation to diligently seek a judicial authorization to search it?
So I think it's the balancing test that's employed in Arthur that ADA Campbell talked about. The court balances the intrusion on the Fourth Amendment rights with the importance of the government interest. And sometimes if you have a case like White, for instance, or let me use a different example, like Arthur, for instance, where this phone was seized after the cars were impounded. And it wasn't seized search incident to arrest, but it was seized where it would be held as evidence because it was potentially evidence of joint venture where you had these two parties communicating with each other.
Can I ask you, so Commonwealth versus Bareilles?
Yes.
All right. Search incident to arrest, and the court says you may seize a cell phone until a search warrant is obtained. You may seize and secure a cell phone until a search warrant is obtained, correct?
Correct.
So here we're talking about the length of time to do that, to obtain the search warrant. All our case law says, well, we go to the reasonableness standard.
Well, Bareilles is different, Your Honor, I think, because Bareilles, the phone is not itself evidence of the crime. That is absolutely true when you have a phone that is seized because there might be seized search incident to arrest, but because there's probable cause or reasonable suspicion that it contains evidence of the crime, not that it is evidence of the crime.
So in these cases, as in the last case, the fact that a child victim has said that the instrumentality to facilitate the rapes was a cell phone, it makes it different than the usual cell phone case.
Yes, it does. And the analysis is the same, but because it's a lawful seizure based on statute, rather than the police don't have to seek a warrant because this was seized lawfully, search incident to arrest at the time the defendant was arrested.
Would you say that goes to our weighing of the factors? It's not dispositive, correct? The fact that it has
it's not dispositive, but I think in a case where you have a phone like this one, a phone that sees search incident to arrest because it is an instrumentality of the crime, I think it's always going to come out that the possessory interest is near zero. So that balancing test it doesn't mean as much as it would if you have a case like Arthur or a case like White where the question is whether there's probable cause that the phone contains evidence of the crime. And I think, there's this both parties in Diaz and in this case in Solis rely on this language from White, and I'll quote it. It says, even in circumstances where a defendant's possessory interest is weak, a delay may be unreasonable if police do not act diligently in applying for a warrant. This is so in part because the unreasonable delay affects not only the person's possessory interest, but also the ability of the judiciary to promptly evaluate and correct that improper seizures. That line quotes a federal case, Burgard, in which a phone is seized based on tips from an informant that it contained child pornography. So there's probable cause that there's evidence on the phone of this crime, and there's also exigency. So they get a warrant to search it 6 days later. So in that case, and in White, the ability of the judiciary to promptly evaluate and correct this improper seizure is significant, but it relates only where the seizure was based on probable cause or reasonable suspicion that the contents of the phone contained evidence. This is true in both White and Burgard, but not in a case like this one or in Diaz. So, and I think that is obvious when you see in this case, when judicial review of the warrant in this case was sought, that's regarding probable cause of the contents in the phone. That's not even evaluating the seizure. It's a completely different question.
But the outer limits of this argument essentially, I think, could lead to the troubling result that there's no limit on how long the police can take to seek a warrant to search a phone, as long as the initial seizure was lawful.
So I don't think that's true, Your Honor.
Okay, so how would we define the line?
So when you have a search incident to arrest like this case where the phone is seized as evidence that will be held throughout trial, I think there is still a conceivably reasonableness is always in play when we're talking about the Fourth Amendment. And, we could conceive of a case where there might be bad faith and the Commonwealth perhaps sees this search incident to arrest, but had no intention of using it as, I'm not sure how this would come out, but had no intention of using it as evidence at trial, but was just holding on to it in the hopes that there might be some information that comes to light that would allow them to get a search warrant to search the contents.
What about when they haven't, I don't even know the right technical language, let's say stabilize the phone so it's not becoming more incriminating after the point of seizure? Wouldn't that be an important factor?
I suppose that could be a factor in this reasonableness test. But I also think that in a case where you have a phone that's seized lawfully, investigations are constantly evolving. To make a bright line rule that cuts it off at a certain number of days when the phone is in lawful police custody would not be good for public safety. It would not be good for law enforcement. It just wouldn't be a policy that would make sense.
But the dynamic nature of the phone might increase the defendant's possessory interest in it.
I think not, because
why not? I mean, I don't have my phone anymore and people are trying to reach me and I need the phone, the physical possession of the phone in order for me to carry on my daily life.
That's well, certainly a defendant could file a motion or try to regain possession of this. But I think in a case like this, where it was seized pursuant to statute, lawfully search incident to arrest, probably the defendant would not be successful. But I think there are mechanisms that protect against this being abused. For instance, if the Commonwealth were to wait until the night before trial to phone seized lawfully and held as evidence, going to be held as evidence throughout trial, Commonwealth waits until the day before trial to seek a warrant to search the contents. Of course, the defendant would be entitled to a continuance at some point. Rule 36 would come into play. I think there are.
Can you just remind me, was this phone unique in some way? I don't remember the details of Solis.
Not particularly. So when police responded to the scene, the victim said that this phone was used as a part of the sexual assault. The defendant took pictures of his genitals. He didn't describe it at that time. At the forensic interview, he said it was a black phone. He thought it was a Samsung. It turns out it was.
Judge Pino actually found the opposite. Judge Pino said it was innocuous and that would make the exception swallow the rule, correct?
He did. So he found that the seizure was lawful, but he said that this is more analogous to White than Arthur, which obviously the Commonwealth disagrees with.
When he looked at, when the motion judge at least weighed the independent evidentiary value, he found it lacking, correct?
Correct. And we would disagree with that. We especially, I think the description of the phone and whether the victim provided a detailed description would go to the weight of the evidence, not necessarily the admissibility. Certainly, this is still admissible evidence to corroborate the
No,
victim's
but under
testimony.
your theory that the phone itself was the instrumentality, the crime, the lack of its uniqueness suggests that the phone lacks that instrumentality, identifying aspects.
Again,
And it's really the content of the phone that the government is seizing it for.
well, certainly that
Content that's
picture,
really about
the picture was ultimately recovered from the phone, and obviously that's compelling evidence that the Commonwealth would intend and want to use at trial. But
right.
just
So
the
I'm just worried
testimony-
about a rule or a legal regime that sets up this rule that you're suggesting, where if the phone is seized incident to arrest, but it's not an instrumentality of the crime, then we do the white factors or whatever the factors are under place. But if it is a child sexual assault and the phone is a garden variety iPhone that might have been used during the victim says it was used, then the government's interest overwhelms the possessory interests of the defendant, even though there's nothing unique about the phone.
And I think where we disagree is the importance of that testimony from the victim, where the victim says, this phone was used to take pictures of my genitals while this man was assaulting me. So I think that is significant. That distinguishes this case from White, distinguishes this case from a case like Crossato, where the phone was recovered, it was next to his head, and there had been a witness who said that he overheard.
So in this case, the victim identified that phone, the actual Samsung phone.
He did. Well, we didn't get to that stage yet because at the
Okay.
motion to suppress.
I thought it was actually the opposite, that the victim said it was a particular color, was in fact a different color.
He said it was black. It was black. He said it was a Samsung. It turns out it was a Nokia, which I think is not a distinction that would render the evidence inadmissible, especially where cell phones are durable goods. Again, I understand Your Honor's point about or concern about the exceptions following the rule, but I think when you have testimony from a victim like that it was used in perpetrating this crime, the description isn't as important as Your Honor is suggesting, because that
It's different than the baseball bat.
Yes.
Right. And so I'm just concerned about like the sort of the end of your argument, right? Like a lot of people have cell phones, and presumably victims will describe that a phone was used.
What if you have
That
a
just
case?
swallows the whole rule, then that.
Well, I think the privacy interest is still protected because the Commonwealth doesn't argue that the defendant doesn't have a privacy interest in this phone. Of course, the Commonwealth has to seek a warrant to get into the contents, and that determination of.
And that's really what the Commonwealth's going for. Like the whole point of seizing the phone is to get the content, not because it was a garden variety iPhone, Samsung, Nokia. I mean,
Well,
it was because of the
disagree.
content.
I disagree. Of course, in this case, the content is significant, but I
The
think
delay in getting to that content seems to be what the constitutional rule is protecting.
But even if, say, for instance, no pictures were found on this phone, I think this phone would still hold evidentiary value at trial for the Commonwealth to introduce it and say, is this the phone that he took a picture of your genitals with? That would be relevant evidence at trial, with or without the photograph that's found on the phone.
So that's a thought exercise you want us to go through with these cell phone cases, to see whether or not the cell phone as a piece of plastic and glass would be admissible and the evidence would be relevant.
Yeah, I think whether it has independent evidentiary value, whether it would be held throughout trial, because what we're really talking about is that possessory interest. So yes.
Well, if we did that and if we accepted that, then now we've got a real problem, because that would accept out the vast majority of phone seizures, particularly if they're incident to arrest, from any kind of meaningful judicial oversight, wouldn't it?
I don't think so, Your Honor. I think, again, if you look at a case like Arthur, they had to get a warrant there because it wasn't seize, search incident to arrest, and because. So actually, I'm sorry, Your Honor. Look at a case like White, where there's no evidence that this phone is used as an instrumentality of the crime. In that case, they were just interested in the contents. So there is then that requirement that police expeditiously get the warrant because there's no lawful police custody of the phone. So the possessory interest is weighing much heavier in that balancing test. So I don't think it would come out that way every time at all.
I don't know that you've addressed the concern. The concern that I have is as I hear the instrumentality kind of theory that you're giving, it seems to really blur the distinction between the police's lawful retention of an object and the constitutionally distinct issue of searching that object.
Which I would argue is protected by a warrant that police must get. The question is the time frame.
Right.
And if you look at the case law, when there's no possessory interest, the time frame becomes less of an issue because the question is.
But it's not the only issue, right? So even if the possessory interest is lowered, the government still has to justify or at least explain the length of the delay. Right?
Well, yes. And I think there's, again, always that reasonableness element. But the reason why we're worried about a delay is because we're depriving someone of their possessory interest. So the purpose of securing this warrant expeditiously is because if there's not probable cause to get the information from the phone, then it has to be returned. But in a case where it's not going to be returned, like this one, that becomes less important. So that balancing test, the government interest just outweighs it entirely.
Chief, could I have one more?
Yes.
So, but what about in the issue of leaving aside the claim of the lowered possessory interest? Let's look at the other side. And here, wasn't the only information, or at least the factors that were presented by the Commonwealth, was essentially the detective's workload?
Yes, that's true. It was the detective's workload. It was the prioritization of.
Weren't all of those things the same things that were argued in White?
Yes, and this case is factually distinct from White because White was seized. Well, first of all, the seizure was unlawful in White, but that's a whole.
Yeah, I'm talking about the reasonableness analysis.
Yes.
In White, weren't these the same kind of things that were offered in White that were rejected in White?
Yes, but this case stands on completely different footing. I would argue that White is really not even applicable here. Arthur is applicable because White, in White, there was a possessory interest. There was, the whole purpose of seizing the phone was because police wanted to look at the contents of that phone. There was no independent evidentiary value.
Okay,
Thank you, Your Honors.
thank you. Attorney Spurlock.
Good morning, Matt Spurlock for Jose Solis. There are a lot of issues here, but I'd like to start with just explaining the value of the rule, why we have this rule. When an officer unreasonably takes a long time to seek a search warrant, he cannot later seek to have that evidence admitted that is gained through getting into the contents by simply saying, oh, I got a search warrant for it. If that were the rule in every case, there would be no suppression issue here. The reason that we have this rule is to guard against improper seizures based solely on the officer's say-so. Removing unreasonable delay from the exclusionary rule would eliminate the rule's deterrent effects on all seizures and every single person who carries a cell phone in their pocket or purse, which is seized by the officer's unilateral discretionary decision upon an arrest. Police could seize any item, including a laptop computer, a home even, for an unreasonably long time.
But that's not this case. This case and the last case, it's the continuing with, we're beginning with, this was a lawful seizure.
It was later determined to be a lawful seizure, sure, and that was litigated, months after, as these are.
Was there a motion to suppress based on the seizure?
So there was a motion and the motion was first based on that the seizure incident to arrest was unlawful, and there was also a motion to suppress because of undue delay. And of course, we know that the motion judge found that the initial seizure was lawful. We're not contesting that.
When was the motion to suppress based on the seizure filed?
It was, I believe, in July. So it was much later, after indictment, and that's how these things usually happen. Right?
So it was after they had obtained the warrant to search it.
Yes, after it was usually.
Should that factor in any way in determining whether the delay in obtaining the I guess there'd be no vehicle by which to move to suppress
So
before he was indicted?
So I take that question to be, does the defendant have to sort of assert a possessory interest?
Right, so he could have requested the return of
Sure,
the phone.
and I think, we start with the presumption that you have a constitutional possessory interest in your possessions, in your effects. That's what Article 14 and the Fourth Amendment say. There's no magic words that you need to say to sort of, make those to make the clock start ticking. This was not a consent search. It was not an abandonment. It was taken from his pocket. So the police were on notice that at that point, we have a search without a warrant, that they had to diligently seek a warrant from a neutral magistrate. And the reason we have this is because sometimes the police could be mistaken.
But you're conflating again the search of the cell phone with its seizure. And here the seizure was lawful.
The seizure was lawful.
When they searched it, they got a warrant.
In my view, one of the reasons for the rule is to protect against unlawful seizures.
Right. And
we
so
now know
what would this rule, I agree with you, but here there was a lawful seizure.
We know, yes, there was a lawful seizure. In White, that seizure, we know that sometimes unlawful seizures happen. And White illustrates that principle, right? That seizure in White turned out to be unlawful. Seizures incident to arrest can also turn out to be unlawful if the police mistakenly or for another reason believe that that phone has evidence of the crime of arrest, and it turns out not to be a nexus, right? We all carry phones in our pockets and cell phones, and those are overwhelmingly going to be the most common types of seizures of cell phones are going to happen incident to arrest. So when the police turn out to be wrong, that makes it especially important that this is presented to a neutral judicial magistrate promptly, not after 110 days. So that's
so you're not making any argument that the magistrate who had before them the search warrant application to search the contents of the phone should at that point have denied the search warrant because the application came too late. That's not part of the analysis that
not part of this analysis, because that's not part of the analysis before the magistrate. But what is before the magistrate is whether there was probable cause to get into that phone. And that is almost the same analysis as if there was probable cause to search the phone initially. That initial decision is made.
Did you mean seize the phone initially?
Yes, because the phone can be seized from a person's pocket incident to arrest because it is evidence of the crime of arrest. And that decision is made by an officer in the competitive enterprise of law enforcement. He's zealously trying to, make an arrest, and he says, listen, I've got this phone, I'm going to take it. We need a neutral judicial officer to step in at some point soon and say, was this seizure lawful? And in this case, it turned out to be. In White, it wasn't. And, in White, it's slightly different because it wasn't incident to arrest, but that makes no constitutional difference. It was taken from.
Well, it doesn't make a huge constitutional difference because in White, that was an entirely independent basis for suppressing all the evidence.
It was an independent basis, but it was an independent basis. There's separate holdings that stands under a bottom.
The defendant in White has a completely different possessory interest than does your client, correct?
I don't agree, Your Honor. I think we all have strong possessory interests in our phones, not only in the phone itself, but a possessory interest in the contents of this phone. And it's different than privacy. I completely understand that. Privacy is about excluding other prying eyes, including the government's. A possessory.
For the defendant in White, they didn't have, it wasn't incident to arrest. They just took it, right? And for no reason.
Well, the officer certainly thought he had a reason, like the officer here, right? Both officers said, I have probable cause to take this phone, and I'm doing it because of exigency. Same as 276-1. You do it because to protect against the risk of destruction and disappearance. Same exact reasoning with the exigency exception to the warrant requirement. One is not incident to arrest. He took it from a school locker.
In White, it was to ferret out this conspiracy, correct? To see if there was a conspiracy with multiple people.
That was the officer's view.
Right.
It turned out to be wrong.
Wait for the question. So here, the issue that's been discussed, and I'd like you to address, is the intrinsic value of the phone as a piece of evidence.
Sure.
Independent of the content.
I understand the Commonwealth to rely heavily upon that, so I'm happy to talk about it. And I think if the court were to acquiesce to that rule, it would nullify White and almost any other case. And that's because the bar for relevance is extremely low. And you can look at, let's take Mitchell.
You wouldn't argue that it couldn't be a factor in considering whether the delay was reasonable?
I don't think it should be a factor.
Not at all.
No, not what I think. It does not reduce one's possessory interest in the phone itself. Now, the police may have an independent reason to keep the phone, and Arthur teaches the police what they should do in that circumstance. They should go and they should get a warrant to hold the phone as evidence. That's what the police did in Arthur. 3 days later, that was good police work. And that's what they should have done here. But think about a case like Mitchell that Burgard cites, or Burgard itself. The phone there was independent, on the Commonwealth's theory, independent evidence of the crime of receiving electronic images of child pornography, right? You need a phone to do that. This was a phone that was connected to the internet. You can possess and receive these images on the phone.
How was it alleged that this phone was used to perpetrate this crime?
The Commonwealth claims and the victim claims that this phone was used to take pictures of him.
Okay. While he was being assaulted, sexually assaulted.
That's the allegation, yes.
Okay. So how is this not a situation where this phone is an instrumentality of the crime? This isn't just a phone in your back pocket when you got pulled over for drugs.
Sure.
Okay? That's what the police know.
I understand the allegations and I understand the
No,
question.
because it's not, I'm just not asking this as a matter of just as an esoteric question. You said in response to Justice Rolla-Hogan's question that it couldn't impact the possessory interest that people have if it's an instrumentality.
Well, that affects the Commonwealth side of the balance. You still have a strong possessory interest because you're presumed innocent and your possessions are yours.
Understood, but how is it not a factor in the possessory interest of the defendant if there's an allegation that they used it as part of the crime?
Your Honor, I think that falls on a Commonwealth side of the balance. I think it gives, if anything, they have a stronger interest in keeping it. But that doesn't overcome the necessity to go before a neutral magistrate and make sure that the officers are correct about it.
So in your view, if you don't have a bright line, I take it you're not advocating for a bright line time limit before which a search warrant must be obtained after a lawful seizure, right? You're relying on reasonableness.
Sure, I rely upon reasonableness.
So what makes the 110 days here unreasonable?
I think
that's specific to this case.
I think the motion judge was correct that this was a one perpetrator, one defendant case. If you look at the warrant in this very case, it's extremely simple, mostly boilerplate language, a couple paragraphs specific to this case. And you hear the testimony from the officers in this case, and it's clear that, they weren't working.
So you think the test is, did the police work fast enough?
Did they work reasonably? They don't have to work quickly. They just have to work reasonably. And so promptly, diligently.
So that doesn't have anything to do, that's a completely new consideration, I think, rather than defendant's possessory interest, whether the object has an evidentiary value, whether it's an instrumentality. Now suddenly you're asking that we evaluate the diligence of the police doing the work necessary to prepare an application for a search warrant.
I don't think there's anything sudden. That's been the test for many years. It's a test that the police need to diligently seek a warrant from a neutral magistrate once they seize without a warrant.
Okay, so if they could have done it faster, then they don't.
No, the test
then
is not
it's
if they-
unreasonable under the Constitution.
That's not my test, and it's not the test in White,
Okay.
not whether they could have done it faster, but whether they acted diligently. And I think the motion judge was correct in holding that they did not act diligently. And I think it's notable that the Commonwealth disclaims any duty to act diligently. If you look at their briefs, they're not really arguing we acted diligently. They say we don't have any duty to get a warrant at any particular time frame. And why? Because, first argument, I can't tell if they conceded it or not, because this is incident to arrest. So, reasonableness doesn't apply. That's what the briefs say, not what they're saying.
I think they've backed away from the absolutist.
I agree.
Okay.
Now, but then they have this independent evidentiary value argument. And what I'm trying to impress upon the court here is that exception would completely swallow the rule. And I understand that in this case, we have a specific, as a term of art, we can call it instrumentality. I don't think that's really the legal term for it. But most cases, the police will be able to make that argument. They will say that
How about Justice George's analogy, where there's a routine drug case and they seize a cell phone from someone. There's no claim that there was a buy or set up a buy, and the police, they seize instant arrest, and later they get a warrant, and they say drug dealers use cell phones, et cetera, right?
Yep.
No independent evidentiary value.
Well, the officers certainly.
Or the murder case where they pull CSLI off of someone who's arrested. No evidentiary value there. That's different than a child saying, the defendant took pictures of me with a cell phone.
It's certainly different, but I don't know if it's a difference with the distinction, because the police officer could certainly say, in my view, there is independent evidentiary value. I'm going to take this from the suspected drug dealer because I think it is instrumentality of his crime to sell drugs. If that's not reviewed, if there's no durational analysis, then that is going to be reviewed a year from now at the pretrial motion to suppress hearing. And this rule is going to apply to every single person, not just, it's going to apply to every person that's arrested in the Commonwealth with a phone in their purse or pocket, right? So we're thinking about, obviously, this is a serious sex.
We're talking about the issue of possessory interest, and why can't we take into consideration those distinctions I just articulated?
You certainly may take them into consideration, but I don't think that they tip the balance in favor of anything like 110 days. I think that the reasonableness still requires diligence, because we know that the police sometimes make mistakes, and that the bar for so-called independent evidentiary value is the bar for relevance, which is incredibly low. It's the computer in Mitchell that can connect to the internet. That is, on a Commonwealth's view, an instrumentality of the crime, because it can receive these images.
But I think what Justice Graziano's question points out is that in this case and the other case, there's more than just a very low level of relevance, right? And can't we take into account that I know this is not your case, but a really distinctive phone cover and a child victim who says that they saw that phone, or even in your case, the child victim, saw the phone.
That may be relevant. In respect to this case, I would like to point out that, the victim testified there was a blue Nokia. No, this was a blue, so he testified it was a black Samsung. It's turned out to be a blue Nokia. It's like, the fact that someone has a cell phone in their pocket right now, I mean, as the cases say, a visitor from Mars would think that, this was an appendage to humans. So it's no different than the fact that you were wearing shoes. It's not very incriminating to have had a cell phone. That is not distinctive. So,
But that's not, you're talking about a different case than this case. In this case, in each of the two cases we were talking about today, the police were immediately made aware that the cell phones were used in the crimes.
Sure, and my client was arrested with the cell phone in his pocket as he got off his shift. My point is that it's not incriminating to have a cell phone in your pocket. And, actually, defense counsel in this case was not too concerned about, that existence of the cell phone as evidence, because it really doesn't do much for the Commonwealth's case one way or the other. And that's, not why the Commonwealth wanted this cell phone. I think that's quite clear from the facts of this case. And I think the motion judge was correct about that too. He knew that what the Commonwealth wanted was to get into that phone. And of course, every time you get into a phone, the Commonwealth can then claim, well, now we're going to introduce the phone as authentication. So we need that too. That is, I guess that's not independent, but it's conditional. Still, it's some different evidentiary value. My point is that if this is the rule, it will swallow the exception, given the wide range of evidence that cell phones can have, including evidence of coordination. So almost any crime where there's co-venturers or alleged co-venturers, we know that those cell phones, as Arthur itself teaches, right? That was the basis of those warrants.
We have to trust judges to be careful, right?
I do trust judges.
Well, I know, I'm saying generally, that's what they do.
And that's when I think we can trust judges, but we can't trust officers. And that's not because they have bad faith. That's because they're working under strenuous conditions and they need some sort of oversight by neutral magistrates. And that oversight will make sure, when they promptly seek a warrant to get into that phone, that they had probable cause to seize it in the first instance. And that'll happen, it'll happen shortly after the seizure, not 110 days later. Not 6 months later. It won't happen at the motion to suppress a year later after indictment. That's the importance of a neutral judicial officer.
Thank you.